Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's premier indoor shooting facility. Of course, that is Security Gun Club right here in Woodinville, Washington. Hey, Illinois, we get to talk again finally. I have been jonesing for a chance to talk about Illinois. We are going to talk about Illinois assault weapon bans, but we're not going to talk about any one of these four cases because, candidly, Illinois, I think all four of them are going to get GVR'd real soon. Don't believe me? Just take a look at some of the language that the Supreme Court used in this opinion here. Now, we are going to talk about a case that really I did not know about until recently, started geeking out on it, but although the arguments may be quite similar, it also gets to use some more of the more recent developments and some of the more recent language used by some of the Supreme Court justices to make this, candidly, a lot more interesting argument. So today, let's spend a few minutes and let's talk about the little-known Illinois assault weapon ban case that just got a lot more interesting. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear. That's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, America and Illinois, we are talking about challenges to the Illinois assault weapon ban case. In this case, we're actually talking about Cook County's challenge. So we got challenges to the Protect Illinois Community Act, we got challenges to the City of Naperville's Act, and this is to a county ordinance, the Cook County Ordinance. We are talking about the case of Viramonte v. Cook County. It is a case that is brought to us both by the Second Amendment Foundation and the Firearms Policy Coalition. We will put double links down below so that you can show them some love. And as I mentioned earlier, this is a challenge to Cook County's semi-automatic rifle ban. Now, although the ban here is quite similar to the ones that are challenged in all four of these cases here, the ones that we've previously geeked out about, and the arguments are essentially the same, and you guys all know the arguments by now. We know under Heller that you cannot ban firearms which are in common use. The only type of firearm bans that we have a history and a historical tradition of actually permitting are firearms which are deemed dangerous and unusual. There can be nothing unusual about the modern sporting rifle, the most commonly used, commonly owned rifle today. Now, this case comes before the Seventh Circuit Court of Appeals on appeal from the Northern District of Illinois. We can imagine where that's going to go. And yes, arguing a constitutionality or lack thereof of an assault weapon ban before the Seventh Circuit is akin to throwing rocks at the moon. But there are some more tools that can be used here by the plaintiffs, and they have done so very appropriately. Now, what do I always say? You never get a second chance to make a first impression. So how does the Firearms Policy Coalition, the Second Amendment Foundation, how do they frame the issue in this case? The question presented by this case is whether the Second Amendment permits the government to ban the best-selling rifle in America and similar semi-automatic firearms. The answer is no. In District of Columbia v. Heller, the Supreme Court held that the 18th century meaning of the word arms is no different than the meaning today, namely weapons of offense or armor of defense. And because the plain text of the Second Amendment does not distinguish between types of bearable arms, the amendment's protection extends prima facie to all instruments that constitute bearable arms. Now, that is language that was used quite frequently by Justice Roberts in the Rahimi case, thus leading to my suspicion that all four of these cases from Illinois are going to get GVR'd back down to the Seventh Circuit with a request for a do-over and to apply the law correctly, therefore making this case in play to be the first one to reach the Supreme Court finish line. The principles established by Heller and confirmed by Bruin should make this a straightforward case. The paradigmatic semi-automatic rifle banned by Cook County is the modern AR-15, and not only is it commonly available, But according to the agency charged with administering the nation's firearm laws, it is one of the most popular firearms in the United States. Ooh, don't you just love that? The first quote there, of course, comes from Justice Sotomayor's dissent in the matter of Cargill v. Garland. And of course, the second quote comes from ATF's rule on unfinished frames and receivers. Well played by the plaintiffs, well played indeed. Now, as I mentioned earlier, one of the big attacks here is the plaintiffs going after the completely ludicrous findings and rulings that was set forth by the 7th Circuit 3-judge panel in the matter of Bevis v. City of Naperville. And as the plaintiffs point out here, of course, this court's decision in Bevis v. City of Naperville complicates matters. Bevis purported to apply Heller and Bruin to an Illinois law similar to Cook County's, but in reality, it crafted a rule that is contrary to both of those decisions and the text and history of the Second Amendment, purporting to draw a line between civilian firearms, which are protected, and military firearms, which are not, a line that the Supreme Court does not itself draw. And if that was the case, can you imagine we would then be trying to arm our military with firearms that were not protected at all by the Second Amendment? But as we know, the 7th Circuit was convinced that there really is no difference between the AR-15 and the M16, and because it is more appropriate for military use and it is so similar, it clearly is dangerous and unusual. As the plaintiffs, though, point out here, the fallacy of that argument is, even under Bevis's flawed understanding of the Second Amendment, however, Cook County's ban on common semi-automatic rifles cannot be sustained. In analyzing whether civilian semi-automatic AR-15s can be distinguished from military fully automatic M16s, Bevis incorrectly focused on the relative firing rates of the two types of firearms while acknowledging that better data may change the analysis. But hey, don't let the data get in the way of where you want to go. Justice Sotomayor provided better data in Cargill. Quote, with an M16 in automatic mode, the shooter pulls the trigger once to achieve a fire rate of 700 to 950 rounds per minute, while, quote, a regular person with an AR-15 can achieve a fire rate of around 60 rounds per minute. That, in addition to basic mechanical function, further demonstrates that the AR-15 is materially different from the M16. And once again, I just love it when you take the words of those that are proposing this and actually use it against them. Now, when the plaintiffs say, hey, this is really a straightforward case, let me show you exactly how straightforward this case truly is. This court could, can, and should resolve this case by applying Bruin and Heller directly. A straightforward application of those cases requires reversing the decision below. And that is absolutely positively true, because not only have they overcomplicated the common use test, in essence, they've completely bastardized this test. This test is a very straightforward test. Is the firearm in common use today? If the answer is yes, we're done with the inquiry. And so as the plaintiffs point out, similarly, the Bevis Court's rejection of common use as dispositive of the historical analysis called for in Bruin cannot be squared with either Bruin or Heller. In Heller, which itself dealt with an arms ban, their handguns, the court surveyed the relevant history and concluded that the only historical tradition that could support banning a type of firearm was the historical prohibition on dangerous and unusual weapons. Yeah, so even though we spend pages and pages and pages, all those pages are spent addressing all the ludicrous arguments that completely have no bearing on the actual legal equation here. When we strip it down to its most simplest form, as again the plaintiffs state, if Bevis is overruled as inconsistent with Heller and Bruin, resolution of this case is straightforward. Heller held that all firearms are arms within the scope of the Second Amendment, and it also held that an arm in common use cannot be banned consistent with history. But despite that, let us remember that a 3-judge panel of the 7th Circuit found that the modern sporting rifle is actually not even protected by the Second Amendment at all. And so plaintiffs had to point out, beginning with the text, Bevis tentatively concluded that modern AR-15s and similar banned semi-automatic rifles are not bearable arms within the meaning of the plain text, because it held that bearable arms were limited only to civilian arms while military weapons are not protected. To decide on which side of the line a given firearm falls, Bevis instructed courts to consider 1, whether the banned arms are useful for self-defense. 2, whether they can be meaningfully distinguished from the weapons used by the military. And 3, whether they are commonly possessed for unlawful means. Yeah, that's right. The Seventh Circuit carved out a new 3-part test that determined whether or not a firearm really truly is in common use. You literally can't make this stuff up. The banned firearms are useful for self-defense, are not exclusively military weapons, and are not commonly used for unlawful purposes. So under Beavis, that means that the Second Amendment's protections are presumptively triggered, and the Cook County ban is unconstitutional unless the court can justify it historically. And again, the plaintiffs are right, because even if that was a true 3-part test, the government is not going to be able to prove any one of those 3 necessary elements to establish that the firearms are not in common use. Okay, so the case once again is Viramonte versus Cook County. We're going to go ahead and link it up down below. We're going to put links down below for the Second Amendment Foundation and the Firearms Policy Coalition, who are leading the charge on this. Obviously, getting in front of the Seventh Circuit is probably not the most productive way of trying to get this thing resolved. However, this case will be a long, long way from over, and we're going to need to add this to the list of other cases out of Illinois that are going to be kicking around, one of which may ultimately decide this assault weapon ban issue once and for all. If you got any questions about this or anything else related to what's left of your Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box. Maybe you got ideas for videos we should be doing here at Washington Gun Law. If you do, go ahead and click on that link right there. Some of the best ideas we had, candidly, weren't our ideas to begin with. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.